Okay, we'll give it maybe another 30 seconds and get started. Some people are joining here. All right. Good morning. Welcome, everyone. My name's Mark Weicker. Thank you for attending the 2025 Student Rights Conference. We're looking forward to an engaging 2 days of discussion and learning. You might know the conference is co-hosted by Abdinor Weicker and MyPAC, the Michigan Parent Advocate and Attorney Coalition. Abdinor Weicker is a private law firm which operates primarily in Ohio, Michigan, and Pennsylvania, but also represents students and educators nationwide in litigation and through advising in Title IX matters. The mission of Abdinor Weicker LLP is to protect the rights and futures of students and educators. Our conference partner, MyPAC, is powered by the Autism Alliance of Michigan and is a statewide grassroots network advancing educational equity and justice for students with disabilities. Through community engagement, strategic organizing, and policy advocacy, MyPAC equips families and professionals to drive systems change. Heather Eckner, who is with us today at the conference, is the Director of Statewide Education at both the Autism Alliance of Michigan and MyPAC. For those of you who know Heather, you know that she is committed to building collective power in Michigan and protecting the rights of students across the state. We are incredibly grateful to have Heather and MyPAC as a partner in the conference, as we believe that hosting the conference together advances the missions of both organizations. Today, we're also glad to welcome attendees from 6 states, including Ohio, Michigan, Pennsylvania, Kentucky, Texas, and California. It's early in California, so thank you for being here. We have presenters from 7 different metropolitan areas, all with unique talents and perspectives on student rights. Just a few housekeeping items before we get started. Importantly, the conference is intended to be both accessible and interactive. You'll see as an attendee or a panelist, you have a closed captioning option available at the bottom of the screen. That's the CC button. You can create a transcript as needed. We will also have a Q&A feature. So we'll be using the Q&A instead of the chat. And so this gives you, all attendees, the ability to ask questions throughout the presentations on the Q&A. And we ask that you do it that way because we have 2 assigned attorneys to answer questions for every session. So we'll have the presenter making the presentation, and then separately, 2 of the panelists will be assigned to answer questions. If that question cannot be answered by the assigned attorneys, we'll try our best to pose the question to the presenter at the end of the session, where we expect to have about 10 minutes, 5 to 10 minutes at the end of each session for questions. And those questions, again, will come through the Q&A either throughout the presentation if they can't be answered, or in that last 10 minutes, attendees may place the questions in the Q&A. And in addition to that, at the end of both days, today and tomorrow, we'll have a 45-minute session panel specifically for questions related to the content or not related to the content, where if we can't get a question answered during the session, we'll try our best to accept that question and get it answered during the panel at the end. If you have a state-specific question, please provide the name of the state in your question. We'll do our best to answer state-specific questions, but may need to follow up afterwards or at the panel discussion as needed. We are recording the webinar, and the recordings will be made available for attendees on the main conference page. This is www.lawyersnumber4students.com/SRC. So lawyersforstudents.com/SRC. And that is the same page that you registered and signed up for the conference. And that is in the chat now. So we'll hope to have those recordings posted on the web page within 7 days of the conference. We will pause this recording at breaks and at lunch so that we hope to have separate recordings for each of the individual sessions, which will make those easier to watch. We also have slide handouts those are available at the same URL, and they are available as of now on the page. So if you haven't opened or downloaded those handouts and you'd like to follow along, you can do that at the same URL. You may have noticed through the agenda that we have a 10-minute break at the end of each hour. We do give you a break, and at the end, before we leave for the 10-minute break, we'll actually have a session evaluation. This is very short. There's a link that we'll provide to you, which you can work through in a matter of seconds, just to give an evaluation to each of the presenters. And there are 6 per day, 6 today and 6 tomorrow, that we'll have you do. But we just ask that you use the link and complete the evaluation before you leave for the 10-minute break. At the end of the day, we'll also have an attendance verification to submit for those of you who need CLE credit. And at the end of the day, we'll also share, before we give you the link to the attendance verification, we'll share the Ohio Supreme Court activity code for this. Poll questions, you'll see I mentioned that this is supposed to be interactive through the Q&A, through the presenter, and then also throughout the course of the day, we'll have some poll questions, which you'll see pop up on your screen, which we will certainly try our best to announce through the speaker or through one of our panelists. But it will pop up, so it will be hard to ignore. Please do participate in the poll questions or quizzes. We'll try very hard to stay on track time-wise. We have Danielle Randolph, who is a panelist here, and she's assigned to give speakers a 10-minute warning, which is an indication to wrap it up and get ready to take questions. And then we have Renee Stromsky is assigned to cut off speakers when their time is up. So we're going to do our best to stay on time. I mentioned that we offer breaks on the hour, so and a 1-hour lunch. So we just ask that you try to return to the webinar on time following the breaks. If you have any technical difficulties or logistical questions, please email intake@education-rights.com. We can put that in the chat. You also received an email reminder that this webinar was happening today. And in that reminder, there was a telephone number that you can also call if email doesn't work for you. And that's, again, if you have any technical difficulties logging back in, issues with using Zoom, please let us know. I think that's enough for me at the moment. I will turn it over to my friend and law partner, Liz Abdenor, for our first session titled Student Rights in 2025, a Case Law Update. All right, Liz.
Thank you, Mark. Hi, everybody. So really looking forward to talking with you all today. I want to give you a little bit of an intro on myself very quickly. So I am a partner at the firm. I've been practicing law since 2007 and primarily handle education of all kinds, including special ed, higher ed, school discipline, all that stuff, Title IX, a variety of other civil rights stuff, and employment law, and FOIA. That's like, I'm really into FOIA. So I'm here in Lansing in Michigan, and but I do handle cases. I have handled cases all across the country. I'm trying to get a little bit more limited in scope in terms of where I'm handling things. So the first thing I'm going to do for you just right off, your poll question is going to be, what year was Title IX enacted? And the answer is going to be 1972. So if anybody wants to write that down right now, okay, there's your poll. Let's get it out of the way so nobody has to worry about that. Again, Title IX was enacted in 1972, if you want to go ahead and answer that, so we can just take care of that for you. Okay, it's telling me panelists can't vote. Okay, so I'll just exit out. Okay. So what I'm going to be talking about today is it's giving me the poll again. Go away, poll. Sorry, guys. I got distracted. Okay, so what we're going to be talking about today is case law updates that have occurred within the past. It's actually going to be the past 3 years because I want to talk about a case from 2022 that are not related to the IDEA. So we're going to be talking about Title IX. We're going to be talking about some of the federal cases that have been decided recently related to the U.S. Department of Education. And we're going to be talking about the ADA and Section 504. So for all of the IDEA related cases, my colleague Corianne Gastall is going to be doing that tomorrow morning. So you're going to get that as well. So let's jump in. So not much of this is going to be good news. I'm sorry to tell you all. I'm sorry to start your mornings off when you maybe haven't even had your coffee yet with a lot of bad news, but hopefully we'll start low and get better as the day goes on. There's not a lot of good news from the courts in the past few years. So the first case I want to talk about, from my view, is the most important case that all of you need to know about. Many people do not know about this case. We get a lot of calls from people that indicate that they don't know about this case. It's understandable because, you know, if you're not a lawyer or somebody who's really enmeshed in this world, you might not. Even a lot of lawyers don't know about this case, I'll tell you, but it's very, very important. So the case is a U.S. Supreme Court case that was decided in 2022. It's called Cummings v. Premier Rehab Keller. So the Cummings case started, it was initially filed in 2018 in the Northern District of Texas. It was filed by a plaintiff who had been denied an ASL interpreter at a rehabilitation facility. And the complaint alleged violations of the ADA, Section 504, and the Affordable Care Act, the ACA. So they were essentially alleging, first of all, that their rights had been violated under those laws because they had been denied their ASL interpreter. They were seeking injunctive relief, and so that's relief that a court can order to sort of make another party do something during the course of or after the litigation is over, something other than compensating the party. And they were seeking damages for emotional distress that they experienced because they had been unable to receive treatment because they didn't have an interpreter. So the Northern District of Texas held that emotional distress damages were not available under Section 504 of the Rehabilitation Act or the Affordable Care Act, and that damages in general were not available under Title III of the ADA. This was a surprise to people. And so the plaintiff appealed the case to the Fifth Circuit, which is the way the federal courts work, is that you have these district courts that cover all or parts of a state. Then there are, I think, 13 different federal circuit courts that are sort of the appellate courts for that. And then the third level is the U.S. Supreme Court. That's the highest court in the U.S. So this plaintiff appealed to the Fifth Circuit. The Fifth Circuit affirmed the lower court's decision, meaning they approved it or they continued it, and they said, yes, this is correct. You actually are not entitled to emotional distress damages. And the rationale from the Fifth Circuit was that the reason for this was because the Affordable Care Act and Section 504 of the Rehabilitation Act create contracts between states and the federal government. The contract is that in exchange for receiving federal funding, the state will agree to comply with certain rules or laws of the federal government, including the anti-discrimination laws. So in this case, you know, the ADA and Section 504. And that therefore, because generally, although this is a big asterisk after the generally, emotional distress damages are not available in contract matters, they're not available here. Now, this didn't make sense to a lot of people, including me, because in fact, emotional distress damages can be available in contract matters. So like, you know, the example I like to give is if, you know, if you have a contract, let's say with a builder to build a deck for your backyard, and the builder doesn't build the deck correctly or doesn't build it on time or whatever, you might have a breach of contract claim against the builder, right? You're not going to have emotional distress damages because the builder, the deck was a month late or something, right? That's not something that you're going to get emotional distress for. You're just going to get, compensation for whatever out-of-pocket costs you had related to the additional time that it took, right? Now, let's say the builder builds faulty steps and your mom falls down the stairs and dies. Then you might have emotional distress damages, right? So just having something be a contract, this is very clear in the law. Just because it's a contract and a contract claim doesn't mean there are never emotional distress damages. And so this decision didn't make sense to a lot of folks. So the plaintiff appealed it to the Supreme Court. And the Supreme Court affirmed the Fifth Circuit's decision. So that means that you cannot get emotional distress damages for any claims under Section 504 of the Rehabilitation Act, so disability discrimination or disability access, the Affordable Care Act. And then the court went further and said, you actually can't get emotional distress damages for any claim that falls under any law that was enacted under the Spendings Clause of the Constitution, because any law enacted under the Spendings Clause of the Constitution is essentially creating a contract between a state and the federal government. So that is also Title IX, sex discrimination, sexual harassment in schools, and Title VI, which is race, color, and national origin, and I think religious discrimination in schools. So we get a lot of calls from people who say, I want to sue my school because my child is being discriminated against, and they've had to go to therapy. Maybe they've even had suicidal ideation. They've had to be hospitalized. Maybe they refused to go to school. Maybe they were in, college or graduate school and they got delayed because they were so distressed and they had to take time off. You and your child are not entitled to any emotional distress damages in those circumstances. Okay, so this is horrible news. If you're hearing this for the first time from me, I'm very sorry. But it's important for people to know, because we get lots of calls from people wanting to do that. And I have conversations with people. It might even be once a week. I'm having conversations with people and telling them why they don't have a claim, unfortunately. There are some now, and the other thing I want you to know is that this is really broad. So, I've even tried and lost arguments about, I had a student who, her law school, she delayed going to law school for a year because she was involved in a Title IX investigation that took almost 600 days. It went well past her undergraduate graduation date. And she was she had to be hospitalized twice for suicidal ideation, and ended up delaying going to law school for a year. And so we had an economics expert prepare a report, detailing the loss of income that she experienced because she would be starting her law career a year later. And the court held, as courts are doing, that because the initial problem, the initial reason that she was delayed was emotional distress, that even though that was an out-of-pocket expense, the source of the delay to law school was emotional distress, and she was not entitled to anything. Okay, so I really need everybody to know this, because I'm telling you, even a lot of attorneys who don't practice this regularly don't know this. You cannot get emotional distress damages for these cases. So let me talk about what do we do instead, right? So one option you have, and it's very limited right now, but it still exists, is to file a complaint with OCR, the U.S. Department of Education's Office for Civil Rights. Now, the important thing to know about that is the timeline. So you can only file with OCR within 180 days or 6 months of when something occurred, which is a shorter timeline than you would have been able to file litigation, because every state has its own statute of limitations for these claims, but they are generally between 2 and 4 years, so you have more time. So if you think that you experienced or your child experienced some type of discrimination and you want to try and address it through OCR, you've got to file that complaint within 6 months. The other important thing to know about OCR is they're not going to be able to do a whole lot for you and your family directly. They will do an investigation. They may make findings that the school is in violation. But what generally happens is that they generally will enter into an agreement with the school of the fixes and the changes that the school needs to make. A lot of times that can be additional training, additional staffing, things like that, so that the school can fix things going forward. But they don't actually have the authority to compensate you for anything. In the past, I have had some success. OCR will offer you a mediation if you file with them, or at least they have in the past few years offered that. I haven't seen that recently, but to be fair, I also haven't been filing much with them recently. And so occasionally I've been able to get sometimes very limited money out of a school through that mediation process, because you can really sort of negotiate whatever you want in a mediation. But I would expect that that's going to be very limited and difficult to get at this point, because everybody knows that, OCR's days are probably numbered, and that if you go to court, schools know that if you go to court, they're not going to have to pay any emotional distress damages. So limited option. Some states also have civil rights, administrative civil rights processes that you can take advantage of. So in Michigan, for example, there is the Michigan Department of Civil Rights. The Michigan Department of Civil Rights will handle any claims that fall under Michigan's Elliott-Larsen Civil Rights Act, which covers all types of discrimination other than disability discrimination, which is covered by Michigan's Persons with Disabilities Civil Rights Act. But MDCR will investigate those claims as well. So they can do investigations. MDCR has beefed up their staffing and their training. They got a significant grant about a year ago, and they're doing a lot better than they used to, from my view. That's my personal view. There are other attorneys out there that I know disagree with me that they've gotten better. I have experienced them getting better and being more responsive and timely. And so they will also offer you a mediation process. And the nice thing about that process in Michigan is that in Michigan, because we have the Elliott-Larsen Civil Rights Act, which protects folks in schools, and the Persons with Disabilities Civil Rights Act, which protects people in schools, you can still potentially get emotional distress damages in Michigan, because instead of filing under the federal laws, which you could still file under the federal laws, you're not going to get emotional distress damages, but you could file for other damages and, this injunctive relief, so asking for change going forward. But if you file under state claims, and you can do both, you can still get emotional distress damages. So that's an option in Michigan. It's not like an easy ride, right? Like, you're not going to just file and you're going to get a check for $1 million, but there's still the possibility to argue for that in Michigan. Ohio is not the same. Ohio's civil rights law is only related to folks in an employment setting. There is not a similar law to file under in Ohio, or an administrative process to go through in Ohio. And then with respect to Pennsylvania, I understand that there is a civil rights law and there is an administrative office you can file with, but that it's not great. So just FYI. And again, the timeline to file that claim in Michigan, if you're going to file it with MDCR, is again 6 months, so kind of limited. So what do you do? Right. So one thing to explore, it depends on if you're at a public or a private school. So again, in Michigan and in Ohio as well, it's limited what sorts of claims you can bring against public schools. So there are laws in both states that limit the liability of public employees with respect to other tort claims. So other tort claims that you might be thinking of are things like negligence, intentional infliction of emotional distress. So in Michigan, those are really going to be almost impossible, because our state law doesn't allow those sorts of claims against public employees. In Ohio, you can bring an intentional infliction of emotional distress claim against a public employee. Again, it's a very high hill to climb to prove that, but it is a claim that you can potentially bring. So that's one option that you have, at least in Ohio. Another thing, obviously, is the state claims in Michigan. You've got that option. And then another thing that I've been really exploring, and I'm excited to continue exploring, I'm very fired up about this, is a claim with a public school that you can potentially bring is a First Amendment retaliation claim. And so the way I've been constructing these claims is, if you or your student or your child report any type of discrimination to the school, and then the school retaliates against you or your student for making that report, or doesn't respond properly to the report, then of course you have a claim of retaliation under, Section 504, the ADA, Title IX, you're not going to get emotional distress damages. But if it's a public school, you also have a claim of, generally, you would have a claim of First Amendment retaliation, because the argument you can make is that the student or the employee is being retaliated against for speaking out about discrimination, which would fall under the First Amendment. And the great thing about the First Amendment is that there are emotional distress damages available, right? So this is sort of where my brain has been going and where I've been trying to pursue some of this stuff. I haven't gotten all the way to the end of litigating any of these. I'm at the very beginning, but I think it's a good idea. So that's an option too. Private schools, different situation. With private schools, you do have the tort claims that I mentioned before. Negligence, intentional infliction of emotional distress are the big ones. Sometimes defamation, or something along those lines. If you've got somebody saying false and negative things about you or your student because they are a member of a protected class. So with private schools, you have got a little bit more options. So that's Cummings. Happy to answer any questions folks have about it. It's a nightmare. It's horrible. It's wrong. It's legally wrong. But we're stuck with it because there's nowhere to appeal it. The Supreme Court has spoken, and the Supreme Court is not going to be overturning itself on that anytime in the near future. So we have to live with it, and we have to find creative ways around it. The only other way around it would be, and this is not going to be something that's going to be effective in the near future, but it is something that I've thrown around as an idea, is to get the statutory language changed. So one interesting thing, and this is my quick elevator speech on why this really makes no sense, is Title VII, which is a law that protects employees from discrimination in the workplace, does allow for emotional distress damages. And so if you are a teacher and the teacher in the classroom next door to you is a known creeper and has been groping people, and the school knows it and they don't do anything, and they come in and grope you, you have a claim of under Title VII for emotional distress damages against the school, your employer. If you are a 5-year-old student and that teacher comes in and gropes you, you do not. Now tell me how that makes sense. It does not make sense. I'm an employee, so not only can I get emotional distress damages, let's say I have to take time off work for therapy or just needing a break from the environment or whatever. I can get lost wages. I can get a bunch of stuff. My 5-year-old can get zero. Okay, they can get nothing financially. That makes no sense. That's not justice. That makes absolutely no sense. Title VII also was not enacted under the spending clause, which is another reason, but it does have language explicitly in Title VII saying that folks are entitled to seek emotional distress damages. So the fix, theoretically, would be if Congress wanted to modify Section 504, the ACA, Title IX, Title VI, and add language explicitly stating that individuals are entitled to seek emotional distress damages. So I had this big hot plan in my head when Cummings was decided that I was going to do that and go to DC and change everybody's mind. And the landscape in DC has changed significantly, and I don't think that would be effective right now. So, and it would also require a lot of work and a lot of people to do it. So, but that's if you really want an idea, that's my idea. So, okay, that's Cummings. I'm sorry for anybody who's learning about it for the first time. So I'm going to give you some good news now out of the U.S. Supreme Court. This is a 2025 case just decided a couple of months ago, AJT versus Osseo. Okay, so let me give you a little bit of context. AJT was a student with epilepsy who had seizures that were so bad that she literally couldn't go to school for the mornings, right? Could only go to school starting at noon. And so her parents were like, okay, she needs a full day of instruction. So school, under her Section 504 plan, we would like you to give her instruction in evening hours, right? So she can get a full school day. And also I think asked for home instruction, a couple things, summer home instruction. So yeah, so the school gave the summer sessions, but refused to give the evening sessions. And so what happened was she was just not getting a full school day, even with the summer, right? So, they denied. And the parents ended up suing initially in district court, which I can't remember where this one was, but it went to the 8th Circuit, which is, Nebraska, South Dakota, that sort of area, I think. Well, I know it's Nebraska. I don't remember the other ones. And so What the court determined was that in that circuit, in the Sixth Circuit, which was the same in the Eighth Circuit, it was the same in the Sixth Circuit at the time, that if a student, this makes no sense, if a student is bringing a claim of disability discrimination, unlike a non-student bringing a claim of disability discrimination who would just have to prove what's called deliberate indifference, that a student has to prove that if the school acted with bad faith or gross misjudgment, okay? Which is what the Eighth Circuit had held at the time. That was the standard in the Eighth Circuit. That was the standard in the Sixth Circuit. That was not the standard in other circuits. Other circuits said, well, why should a student have to prove more than a non-student with respect to disability discrimination, right? Everybody who's trying to prove disability discrimination should have to prove the same thing. But no, not the Sixth Circuit where we are, or the Eighth Circuit. They had held that schools would not be held liable for disability discrimination unless the plaintiffs were able to prove bad faith or gross misjudgment by the school, which is almost impossible to prove, right? You can make a lot of errors and not be acting with gross misjudgment. So good news, the Supreme Court unanimously decided that this made no sense, and that students with disabilities should not be subject to a higher standard of proof than non-students with disabilities with respect to disability discrimination. And so it held that the standard across the country, including the Eighth and Sixth Circuits now, is the deliberate indifference standard that everybody was subject to before. So that is some good news. So you're not going to get emotional distress damages, but if you want to try to prove a discrimination case against a school, you don't have to prove bad faith or gross misjudgment anymore. Okay. I'm going to talk now about several of the cases that have been decided recently related to the U.S. Department of Education. Okay, so the first one I want to talk about is a very recent, as of 3 days ago, U.S. Supreme Court decision. Okay, so that case is McMahon v. New York. It was filed by a group of 21 states, as well as, I believe, I think this one had, I don't know if this one was the one that had unions involved, but no, I think this was just filed by states. And so the states filed the lawsuit after the Department of Ed announced on March 11th that it was going to be initiating a workforce reduction in force of about 50% of the Department of Education's workforce. And so the states initially filed in the federal district court in Massachusetts, represented by attorneys general. And so they were seeking injunctive relief to prevent the federal government from initiating this reduction in force. They filed a request for a preliminary injunction, which is an injunction preventing anything from being changed during the course of the litigation. So asking the court to order that the federal government can't lay anybody off until the end of the lawsuit at least. The court at that time, the Massachusetts District Court, agreed with the employees, and the preliminary injunction was granted. And so you may have seen in the news that a bunch of emails and outreach were happening to federal employees to tell them to come back to the office, which of course was its own can of worms, because a lot of those people were like, bye, or were already seeking, or maybe had found new employment. But at any rate, they were required to start trying to bring them back. So then the government appealed to the First Circuit Court of Appeals, which is that second level appellate court for the District of Massachusetts. It didn't initially rule on the preliminary injunction, but it said, wait a second, we're going to issue a decision very quickly. So it then issued a decision saying, no, we're not going to remove the stay. This is appropriate. These folks have what the court has to determine is that the individuals seeking the stay have a likelihood of success on the merits, meaning that it's likely that they'll win their case. First Circuit says this is likely. We're going to maintain this stay in place. That you got to hire these folks back. So then the federal government went to the U.S. Supreme Court, and the U.S. Supreme Court on July 14th issued an order staying the preliminary injunction with no explanation whatsoever, just saying, nope, you can fire these people, keep it moving. There was very strong dissent by 3 of the justices, arguing that essentially this is unlawful for the federal government to be doing this. The U.S. Department of Education was created and implemented by Congress. It's not within the scope of the presidential powers to limit or essentially dissolve it. And if a president comes before us asking us to do something that's unlawful, our job as judges is to stop it. But they were the minority, and the majority said, go right ahead. So unfortunately, now those layoffs can go ahead, with one important exception, which I will talk about next. So Department of Education is allowed to proceed with layoffs as of Monday. Okay. So another important case for everybody to know about. This one is a case that is in the District of DC right now. I think, hang on, let me make sure this is the right one. No, I'm not on the right one here. Hang on. This one is with also the District of Massachusetts. Okay. So, different lawsuit filed against the federal government. It's called Victim Rights Law Center versus U.S. Department of Education, filed in the Western District of Massachusetts in April. This is also related to the reduction in force. And we actually, very excitingly, we have a family who are plaintiffs in this lawsuit. So that's very cool. So the Victims Rights Law Center filed a complaint along with several students and parents, alleging that essentially that the government's decision to reduce its employees, including at OCR, specifically related to OCR, was going to negatively affect students across the country, because students were entitled to have the ability to file complaints with OCR, and to have civil rights investigations completed when they filed complaints with OCR. So the plaintiffs were asking that the reduction in force be declared unlawful, and that the reduction in force be eliminated, or that that be stopped. And so another thing that happened right around this time in early March was that the U.S. Department of Education closed 7 of its 12 OCR offices, the ones that handle these civil rights investigations, including the Cleveland office, which handled all complaints for Michigan and Ohio. So now all of those complaints are being handled by the Denver office. The Denver office also got assigned all complaints from the Chicago office. So the Denver office is like completely at sea right now, because these offices, if you know anything about them, already did not have nearly enough folks to handle the number of investigations that they were handling. They'd been underfunded for many years. So now you've got triple or more the number of cases assigned to this poor Denver office. And they're just absolutely underwater. And none of my cases that have been assigned there have been going anywhere. So the preliminary injunction was granted in that case, and that was on June 18th. And so what the court found was that even though the injunction had been granted in the McMahon case, which, remember, now that just got overturned, so that injunction is gone, reduction in force is going forward. Even though there was an injunction granted in that case, which the government was arguing, look, why do we need another injunction? We've already got one. The court was like, well, this is different, because this is separate. The harm that these plaintiffs are going to suffer is different, because the McMahon case is about employees and non-compliance with the Administrative Procedures Act related to how employees should be treated. These are students alleging that they have a right to have investigations handled. So these are different people. They're entitled to a remedy that's separate. So that injunction is still in place, okay, as of May 2nd, or no, June 18th. Sorry about that. My dates are all over the place. I'm going to give everybody a handout, so don't worry that you have to remember any of this. The attorneys in that case are expecting the government to appeal, but no appeal yet. Okay, so we are expecting that there will be an appeal happening from the government. And, I'll be honest with you, I'm expecting they'll eventually appeal to the Supreme Court, and this will probably be overturned. But for now, OCR exists. The other case that's very similar is there was a case also filed Very similar in the District of DC called Carter v. U.S. Department of Education. We also have a family who is the plaintiff in this lawsuit too. So we're super excited and proud of our families for getting involved in these really important cases. So this one was similar. This is also a case. This is a case that also includes COPA. COPA is a plaintiff in this case. So anybody who is familiar with COPA, they are awesome. They are on the front lines of this too. And they are plaintiffs in this lawsuit as well. So this case has been stayed. There has not been any preliminary injunction issued in this case because on June 16th, there was a status report and the judge in that case was like, look, there's a lot going on with these other cases that are related. I'm not going to issue an order that might conflict with anybody else. We're just going to put this one on hold. So this is on hold, very similar to the victims' rights lawsuit in terms of what it's asking for. And so, you know, it's on hold. Okay. One other case I want everybody to be aware of, which is a Sixth Circuit case, and then we'll go to questions. So this is a case before the Sixth Circuit. The case is called YA v. Hamtramck Public Schools. This is a case that was filed by a group of parents of 3 students in Hamtramck Public Schools, right? Alleging that their students' rights were being violated under the IDEA, which I know we're not going to talk a lot about the IDEA, but I am going to talk a little bit about this one. You won't have to hear about it tomorrow. I coordinated with Corianne. And the ADA and Section 504 of the Rehabilitation Act, arguing that, first of all, that Hamtramck was in violation of the IDEA because, well, I should correct myself, that Hamtramck Public Schools, Wayne RESA, Wayne Regional Educational Service Authority for non-Michigan folks. Michigan has this system of intermediate school districts, very confusing. They're like sort of like county-wide in-betweens between individual school districts and the state. And then also the Michigan Department of Education. So the parents' attorneys named all 3 of these entities as defendants in the case. And they said, you know, these 3 entities have failed to provide services to our kids under the IDEA. And they have also violated the ADA and the Rehabilitation Act by failing to provide appropriate services and accommodations and discriminating against our kids. So the state of Michigan, on behalf of MDE, filed a motion to dismiss the case saying, first of all, you can't sue us under the IDEA. I'll explain it a little bit. It's complicated, but they argue that. And then they also argue that we are immune to the ADA and 504 claims under the principles of sovereign immunity. We're a state. What that is essentially is that the state has not consented to be sued under those laws. They can't argue that particular argument with respect to the IDEA because the IDEA explicitly says that states can be sued in certain circumstances. Okay, so they appealed that to the Sixth Circuit. So the Sixth Circuit issued a decision about 2 months ago. I think it was March or April, 2 months ago, let's say. And the Sixth Circuit agreed with MDE and they said, you're right, MDE, you're not allowed to be sued under Title II of the ADA. You can only be held responsible for your own actions. You can't be held responsible for the actions of the school district or the ISD. That's what we call these intermediate school districts in Michigan. You also can't be sued under Section 504. And oh, by the way, we also don't think you can be sued under the IDEA. Ha ha. So this was like just an absolutely horrific decision. We didn't find out about it until after the decision was made, and COPA didn't either. And COPA was like beyond distressed over this. So our firm, COPA, a lot of other folks, MyPAC, a bunch of entities, Disability Rights Michigan, Disability Rights Ohio, Disability Rights Kentucky, Disability Rights Tennessee, a whole bunch of us got together and we drafted 2 amicus briefs, which are briefs that you write to a court that you're saying, hey, I'm not a party in this case, but I got something to say on it and I have a reason that you should listen to me. So we filed these 2 amicus briefs saying to the court, hey, you need to have a rehearing on this. This was the wrong decision for a long list of reasons. That's why we needed 2 briefs to fit it all in. And they accepted our briefs and read them and said, nope, too bad. We're not going to do a rehearing. So now there are oral arguments that are going to be scheduled on the issue of whether the IDEA claims can be brought against MDE or not. So this is a big issue that I and several of my colleagues in our office and also several folks from Disability Rights Michigan and a couple other firms have been litigating for a long time, is that, MDE will argue that it can't be sued under the IDEA unless you're suing it with respect to issues that a school did not resolve and that you were not able to resolve through a due process hearing. Okay. That's what it's arguing is the only thing you can sue it for under the IDEA. In some circuits, there's case law finding that a state Department of Education can be sued due to its supervisory authority and responsibilities under the IDEA. The Sixth Circuit has not decided that question yet. And the judge that we have in a case in the Western District of Michigan is really hesitant to decide that, because they don't like to decide this stuff at that level. They want the courts of appeals to decide it. So apparently this case is going to decide it. And I'll be honest, I'm really worried about it because I'm not impressed with the plaintiff's attorneys on this case. So I reached out to COPA to see how they feel about us maybe trying to do another amicus brief before the oral arguments in this one. So fingers crossed that they'll be on board with that, because this is a really important question for everybody in Michigan, Ohio, Kentucky, and Tennessee. So that is what I wanted to talk about. We have got 14 minutes left. So why don't we dive into questions? And I don't see anything open in the Q&A. So question and answer people. I don't know if you have anything else you want to ask me or if anybody wants to just ask, but.
I'll ask you, what do
Yeah.
you predict is going to happen ultimately with the U.S. Department of Education and OCR?
Yeah. Yeah, I think it's going to get shut down. I do. Yeah. I think that's what's going to happen. I mean, the Supreme Court is making consistent decisions, demonstrating that at least a majority of the justices believe that it is within the president's executive authority to shut down these congressionally created agencies. And the big problem is that Congress is not fighting him on that. So I think that's the direction that this is going. I do. There's this perception or argument that the states should be handling everything on their own. But that's not what the statutes say. But if Congress isn't going to defend the statutes that it enacted, ultimately, I think that's what's going to happen.
Liz, we have a couple more questions in the
Yeah.
chat. So one of them, how would you say Cummings has affected victims' willingness to come forward in Title IX claims, if at all?
It hasn't yet because nobody knows about it, which is why I'm trying to tell people. Yeah, no, they're still coming forward. They don't know. They don't know that they can't get a motion. I get calls every week. Our firm gets calls every week from people with Title IX claims who say that they want to pursue emotional distress damages against their schools. It's not affecting them, but it should be affecting them. When I'm talking to folks who are deciding whether I've actually always, so little background on me if people don't know it, I worked in the Title IX office at Michigan State University during Larry Nassar for 3 years, okay, 2015 to 2018. So I've got some insight into Title IX offices, and my advice since then has always been think very carefully before you even go to a Title IX office, because that investigation process, I have had numerous folks who have gone through it tell me, and I believe because I've seen it, that the investigation process was worse than the abuse itself. Okay. So, but that being said, so I tell folks, think carefully. What are your goals? When I'm representing folks who are thinking about going through the process, we identify what their goals are and if the Title IX office is even going to be a reasonable place to achieve those. Like, should they even bother? Now, that doesn't mean that you don't have a claim against the institution. However, to have a legal claim against an institution, it's almost impossible to create a legal claim if you don't give the institution the opportunity to investigate and remedy it, because that's what they're going to argue in court is you never reported it. So we didn't know. So how could we do anything? Therefore, we're not responsible. So, but survivors, victims, etc., they do not know this. So it so far has not affected people's decision. I think people's decisions are generally primarily affected by whether they think their school is going to handle their report properly or not, which is really a school by school determination, or advice they might be getting from parents, therapists, advocates, that kind of thing. So far, I don't think there's been any effect, but I think that's because people don't know about Cummings.
Next question, what, can you just clarify the name of the seizure case you mentioned?
Yes, that is AJT versus Osseo. And I put together an outline of everything, and that'll be in the materials that everybody will receive. And that's got all the case names and citations for you, along with summaries.
Perfect. And we have a few more. So how do you stay so optimistic to keep fighting the good fight despite the constant negative blows from the judiciary?
Right. Because maybe I've never had that great of an opinion of the judiciary, even though I'm a lawyer. So that helps. The way I stay optimistic, I'm going to tell you all, and I tell this story a lot, and half the people listening to this have always heard this story, already like heard it a gazillion times. So, when I was in law school, I knew I wanted to help like survivors of violence, and I was working with a nonprofit that represented survivors in getting protection orders. And I had this case where I was representing this mom. She was from India. She was an immigrant. She knew nobody. She didn't speak English. And she had 7 kids with her abuser who was, I can't remember if he was a permanent resident or a citizen. He was also from India, but, you know, had status here. And we got her the protection order, and we were walking out of court, and she looks at me, and remember, she has 7 kids and she has nobody. And she says to me like, okay, like, what do I do now? And I was like, well, what do you mean? And she's like, well, I rely on my abuser for money and housing and legal status. Like, what do I do now? And I went home and I laid on my bed and I cried for like 3 hours because I was like, I just ruined this woman's life. I just ruined her life. And I kind of did ruin her life because, to be fair, I had not given her advice on any of those things before I got her this protective order, but that's part of the learning process, right? So, you know, as you're learning how to be an attorney, you make a lot of mistakes because you don't know everything. But you know, I wasn't acting rogue. Like, I was with a nonprofit. They helped her get services and got her into a shelter and all that stuff. But in the moment, I was like, shit. And so I was like, well, I can't do this anymore. I was like, I'm not going to do this work anymore. I'm just going to ruin people's lives. Took my first job out of law school at Legal Aid in Cincinnati, and they assigned me to the family and domestic violence unit because of all of my experience representing survivors. And I told them I didn't want to. I was like, don't assign me to that. I don't want to do it. And they did anyway. So I was like, crap, now I'm just going to ruin a ton of people's lives. And so what happened though is I represented people, and it was terrible. And in a lot of the cases, I was representing people in fighting over their children for custody from an abuser. In one instance, years after I had gotten custody for my client of her very disabled child from her very abusive abuser, in a visit, the child died with dad. And like, it was devastating for me. I still think about that kid probably every day. So, but what I saw in representing those families and those folks was they get to the other side, right? It doesn't matter. It actually, this is my sort of philosophy on being a lawyer too, which is probably going to sound weird. I actually don't care as a lawyer. I care, but like, I don't care what the outcome is. I see my role as a lawyer as being like I'm like a Swiss Army knife for somebody who's going through the worst thing they've ever gone through, or one of the worst things they've ever gone through. And my job is to get them to the other side. And I started seeing in my first couple of years as a lawyer, people getting to the other side. And I realized that it actually doesn't matter how bad of a thing people go through, as long as they feel like they have support, they will get to the other side and they will rebuild and they will be resilient and they will be okay. Like, even if their child dies, right? So that's how I stay optimistic, is that I don't see the outcomes of any of this crap. And the other thing I really keep a long view on is history. I think a lot about history. People have been through a lot worse shit than what we're dealing with right now. You know, I read, or there was a creator or something I was watching, I think on like TikTok or something. And she's like, okay, you know, everybody's complaining about whatever's happening now, but like, I want you guys to think about a slave on a plantation in the year 1700. And that person was fighting for freedom, and freedom wasn't going to come until they were long dead. And I'm like, gives me some perspective here, right? Like, I'm not saying this stuff isn't serious. It is. But like, let's think about everything that we collectively as Americans have been through. We collectively have been through some shit. And so this is, and sorry for all the swearing. I should probably not be doing that, but the crap. And so, we're going to make it through. We got to focus on the long game here. The other thing, and I will stop with this, but this is my last thing that I tell everybody. This festering boil of people wanting to continue discriminating against other people has been building for a long time. Systems don't go down without a fight. The system that's been in place where everybody other than rich white men have been benefiting has benefited those people for a very long time. They're not going to go down without a fight. This boil was going to pop at some point, okay? We were going to have to deal with this. So here we are. Hopefully we're there, right? I mean, maybe there's worse. We'll see. There probably is. But like, whatever the worst is, we were always going to have to go through the worst before we could get to the other side of it. We're going to have to deal with this. We're going to have to. So let's just deal with it. So that is my long-winded how I stay happy and smiling.
Hey, Liz, I got a question.
Yeah.
You talked a little bit about Cummings
Yeah.
and how that takes away that avenue for relief, at least in terms of emotional distress damages. Can you talk a little bit about, just the administrative process, in either K-12 or higher education in regards to what, I guess, relief you can get through that process in school?
Yeah, absolutely. Yeah. So Title IX specifically, Mark, is that what you're asking?
Yeah.
Okay. Yeah. So Title IX, it's an interesting law. It was significantly modified in 2020 during the last Trump administration. There are some good and bad things in those modifications. One of the good things is that the requirements under which schools have to handle and investigate reports of Title IX violations is very specific. So in any school, a student or in K-12, a parent can make a written report. It's got to be a written signed report submitted to the Title IX coordinator saying, I want you to investigate this Title IX violation. The school then has to open an investigation. They can offer informal remedies, which sometimes is the right option. Sometimes people want a formal investigation. I don't have time to talk about the pros and cons, but I think in Jess's presentation, she will. Basically, you submit a complaint, they'll open an investigation. The way it works is that they will interview individuals, they'll collect evidence. Sometimes there's text messages, photos, written documentation, whatever they may be. Interview both the person filing the complaint and the person about whom the complaint is filed. Everybody has a right to an advisor or support person during that process, and then the school will make a decision about whether the policy was violated. In K-12 schools, that's generally just done by a separate individual in writing through a written report. In higher ed, it has to happen after a hearing. So they'll have an actual hearing. Each party will have an advisor that asks the other side questions. There's a hearing officer or hearing panel, and then they'll issue a written determination. And then there's an appeal process that schools can also, or they do now have to also have in place, so that if you disagree with the decision, there are certain limited grounds that you can file an appeal and then have that decided. So that's basically the process.
And what are some of the sanctions that schools can issue against the respondent?
Yeah, so if a school determines that a respondent has violated the policy, they can put the student on probation. They can initiate a permanent no contact directive where the respondent can't communicate or do, attempt to communicate with the claimant, the claimant being the person who was affected. A suspension is an option. Expulsion is an option. Trying to think what else. I've seen sometimes school, like higher ed, sometimes they'll order counseling or something like that. That's generally what the spectrum is.
Thank you.
Yeah. 2 more minutes if anybody has anything.
The
All right.
evaluation link is in the chat box if attendees haven't seen it yet, but if everyone could click on that and complete the evaluation, it's quick again. I think that
Great.
will take us out.
Great. Well, thanks, everybody. We are so excited to have you all here, and I hope this was helpful and informative and not too depressing. But I promise all of the rest of the presentations today will be more optimistic and we'll give you a lot more tools. And thank you all for being here.
Thank you, Liz.
Thank you, everyone. Like I said, or like Mark said, we have our eval link in the chat box. If you guys wouldn't mind filling that out, that would be wonderful. We will now take about 10 to 11 minute break until 10 a.m. And we will see you at that time for our next presentation.